Chapter 7 State of Exception. Article 137. The President of the Republic, with the consent of the Cabinet, may decree for a determined time period in all or part of the national territory, and with a duty to report to Congress or permanent assembly, a state of exception as provided for in this article. 1. A state of emergency in case of disturbances of the peace or the domestic order, disasters, or serious circumstances affecting the life of the nation. In this case, the exercise of constitutional rights relating to personal freedom and security, the inviolability of the home, and freedom of assembly and movement in the territory as set forth in paragraphs 9, 11, and 12 of Article 2 and in paragraph 24, subparagraph F of the same article, may be restricted or suspended. Under no circumstances shall anyone be exiled. The state of emergency period shall not exceed 60 days. Its extension requires a new decree. Under a state of emergency, the armed forces may assume control over domestic order if the President of the Republic so decides. 2. A state of siege. In case of invasion, foreign or civil war, or imminent danger that such events might occur, with mention to those fundamental rights whose exercise is not restricted or suspended, the applicable period shall not exceed 45 days. When the state of siege is declared, Congress convenes by law. Its extension requires congressional approval. Chapter 8 The Judicial Branch. Article 138. The power of administering justice emanates from the people. The judicial branch exercises it through its hierarchical entities in accordance with the Constitution and laws. In all proceedings, when an incompatibility exists between a constitutional and a legal rule, judges shall decide based on the former. Likewise, they shall choose a legal rule over any other rule of lower rank. Article 139. Principles and rights of the jurisdictional function are the following. 1. The unity and exclusivity of the jurisdictional function. No independent jurisdiction exists, nor shall it be established, except regarding the military and arbitration. There are no judicial proceedings by committing or delegation. 2. The independence in the exercise of the jurisdictional function. No authority shall remove cases pending before a jurisdictional body or interfere in the exercise of its functions. Neither shall they invalidate orders under res judicata, halt proceedings underway, nor modify sentences or delay their execution. These provisions do not affect grants of executive clemency or the authority of congressional investigations, the exercise of which may nevertheless not interfere in the jurisdictional proceedings or have any jurisdictional effect. 3. The observance of due process and jurisdictional protection. No person shall be diverted from the jurisdiction predetermined by the law, nor shall anyone be subjected to proceedings other than those previously established, or be tried by exceptional jurisdictional bodies or special commissions created for that purpose, whatever the official title. 4. The publicity of proceedings, unless otherwise provided by law. Judicial proceedings involving the liabilities of public officials, crimes committed through the press, and those relating to fundamental rights guaranteed by the Constitution are always public. 5. The written explanation of court orders at all levels, except merely procedural decrees, with express mention of the applicable law and the factual grounds on which they are based. 6. The plurality of the jurisdictional level. 7. Compensation, in the manner prescribed by law, for miscarriages of justice in criminal trials and arbitrary arrests, with prejudice to any liability that may be determined. 8. The principle of never failing to administrate justice, despite loopholes or deficiencies in the law. In such cases, the general principles of law and customary law must be applied. 9. The principle of the inapplicability through analogy of the criminal law and laws restricting rights. 10. The principle that no one shall be punished without judicial proceedings. 11. The most favorable application of the law to the defendant in cases of doubt or conflict between criminal laws. 12. The principle that no one shall be convicted in absentia. 13. The prohibition of reopening closed cases with a final order of conviction, amnesty, pardons, stays of execution, and prescription produce the effects of res judicata. 14. The principle that no person shall be deprived of the right to defense at any stage of the proceedings. Every person shall be notified immediately and in writing of the causes or reasons for his detention. In addition, he has the right to communicate in person with and be advised by the legal counsel of his choice upon being summoned or arrested by any authority. 15. The principle that every person must be informed immediately and in written of the causes or reasons for his arrest. 16. The principle of free administration of justice and a free defense for persons of limited means, as well as for everyone in those cases stipulated by law. 17. The participation of the people in the appointment and removal of judges in accordance with the law. 18. The obligation of the executive branch to collaborate in trials when required. 19. The prohibition of the exercise of the judicial function by anyone who has not been appointed in the manner prescribed by the Constitution or the law. Jurisdictional bodies may not confer such an office under penalty of liability. 20. The principle that every person has the right to make analysis and criticisms of court orders and sentences within the limits of law. 21. The right of inmates and convicted individuals to be provided suitable facilities. 22. The principle that the purpose of the criminal justice system is the re-education, rehabilitation, and reintegration of the guilty into society.